Mr. Moore, you're both in the United States Department of Education, right? Same department.
That's correct.
And Mr. Moore has just talked about regulations that you are proposing under the Violence Against Women Act amendments to the Clery Act. So you've gone through a public notice, or you're about to go through a comment period on these, at which institutions will have a chance to say what they think about it. Anyone else will as well. Is that correct?
That's correct, Senator.
Now, Ms. Lhamon, you talk about something called guidance, and I've got here about 66 pages of guidance under Title IX. Now, do you expect institutions to comply with your Title IX guidance documents?
We do.
You do. Then what authority do you have to do that?
Well, it is our.
Why do you not then go through the same process of public comment and rule and regulation that the same department over here is going through under the Clery Act?
Well, we would if they were regulatory changes, but
why are they not regulatory changes? You require 6,000 institutions to comply with this, correct?
We do.
You do, even though you're just making an edict without any chance for public comment, without any regulatory approval? How can you do that?
You know, I would not describe it that way.
I would. How can you do that? Why would you not go out and ask institutions and people who might have been assaulted what they think about your guidance before you apply your guidance to 22 million students on 7,200 campuses?
First, we do. We have quite a long list of conversations that we've had in person and through letters and.
But you're in the same department of the United States Department of Education. Under the Clery Act, he's going through a regulatory process which publishes what he's doing after stakeholder meetings, after discussions. He's asking for comment. Then there's a regulation. Then the Congress actually has a chance to weigh in. But you're just over there issuing your own opinion, as far as I can tell, correct?
No, that's not correct. We have gone through the regulatory process.
Well, who's responsible for this? You?
I am, yes, but
right.
those are
What's
not just my opinion. That is actually what the law is, and it's guidance about the way that we enforce.
I thought we made the law. Do you make the law?
I do not make the law, but
all right, then
we
why do you
explain
say
it.
this is what the law is?
Because it's an explanation of what Title IX means.
Who gave you
campus.
the authority to do that?
Well, with gratitude, you did when I was confirmed.
We told you that you could make the law in Title IX. Then why does he go through a public notice and comment under the Clery Act if you don't have to?
I do have to go through a public notice and comment period when we regulate. This is not regulatory guidance.
Well, I greatly disagree with that. I greatly disagree with that. I think what you're doing is writing out detailed guidance for 22 million students on 7,200 campuses, and it's just, it could be your whim, your idea. We make the law. You don't make the law. Where does such a guidance authority come from? Is it just grown up over time? And why would the same department have, how often do the two of you meet within your department? How many times in the last year have you met?
I couldn't count them because it is so many. Jim and I work together very, very closely.
Mm-hmm. And did you have input in his rules that are proposed to be rules?
Yes, a member of my team has been part of the notice and comment process.
Mm-hmm. Well, I'm very concerned about the arbitrariness of an individual in the department saying what the law is when I thought we were supposed to do that. I understand that your two offices have signed a formalized agreement to better handle Title IX and Clery Act complaints and to share information. Is that correct?
That's correct.
And is that because in the past you've really failed to coordinate and created a good deal of confusion on college campuses about how to coordinate the responsibilities for dealing with sexual assault as they look up at Title IX and look up at the Clery Act?
Well, I again also wouldn't describe it that way, but I do think that there was room for growth for us, and I'm really pleased with the collaboration that my office and the Federal Student Aid Office have been able to enter into and to effectuate for students, certainly in the 10 months that I've been here, and I think that it's been working extremely well.
What kind of formal procedures did you have to discuss your guidance with institutional officers who have to comply with your guidance? How many meetings did you have with institutional officers around the country?
Well, I don't have the number off the top of my head, but it took about 3 years to prepare that question and answer document that followed the 2011 guidance. And in those 3 years, we had many, many meetings with college and university officials, with associations of college and university officials, with student activists, with survivor organizations, with Title IX coordinators. We had just a tremendous number of actual in-person meetings, telephone conversations, letters that came to us, asking questions, telling us what more we need. So it was a long, iterative process that involved many stakeholders with many different opinions so that we could give them greater guidance and clarity about the ways that we enforce.
My time is up, but I would say to my colleagues who are here, I think we should carefully consider, not just in this case, but in other cases, whether with FDA or anything else, what the difference is between a law and through a regulation, which is proposed by the Department of Education, and this growing business of issuing guidance where there's no opportunity for the kind of public comment and approval that the regulatory procedure has. Thank you, Mr.